Welcome back to Indiana Newsdesk. A Supreme Court decision this week expands workplace equity for LGBTQ employees. Many Americans already believe that federal law protected lesbians, gay men, and transgender people from being fired or otherwise discriminated against at work. But that wasn't the case. Deborah Whitus from Indiana University's Maurer School of Law joins us now. Deborah, this ruling, a major victory for LGBTQ human rights. Can you just explain the importance of this decision?
Well, yes. I mean, as you said, it really wasn't clear under federal law that people were protected from discrimination on the basis of their sexual orientation or their gender identity. There were state laws that did that in some states, but not in others. And so this just makes really clear that anywhere in the country, you're protected by our civil rights laws now.
Now, if a lot of people already believe the Civil Rights Act protected LGBTQ, so will we see a lot of change with this new ruling?
I think we will. I mean, I think that now that it's clear and it's been decided by the Supreme Court, it feels safe for people to start to be more comfortable disclosing at work, coming out, bringing a same-sex spouse to a company event, being open about the idea of transitioning gender. I think that we'll see more employees being comfortable sharing these key parts of their identity.
I wanted to ask about things that this ruling does not do. One of the first questions that comes to mind is whether employers can fire an LGBTQ person for religious reasons. Now, in Indiana, of course, you remember two former
Yes.
school guidance counselors filed complaints against Roncalli High School, as well as the Roman Catholic Archdiocese of Indianapolis. Does this decision impact any of those cases?
What this decision does is make clear that that's an open question. So there are some special rules that can apply to religious employers when it comes to making decisions about employees who play a ministerial role. And so one key question is going to be how big that scope it is. We know that a teacher who's sort of an ordained minister too and is teaching religion all day long, that can be considered a ministerial role. But it's not clear if somebody like a guidance counselor or say someone working at a soup kitchen who says grace before serving a meal, is that enough to make someone a minister and sort of fall within this exception?
This decision also doesn't apply to workplaces with fewer than 15 people. Are there other workplace equal rights issues that aren't addressed in this ruling?
Well, with the smaller workplaces, so in Indiana, for example, our civil rights law covers employers that are smaller, so anyone who has at least 6 employees. And our civil rights law, like the federal law, prohibits discrimination on the basis of sex. And so what the Supreme Court decision did is it explained that if you discriminate against someone because of their sexual orientation or their gender identity, you're necessarily discriminating against them on the basis of sex, because essentially, if it's a woman married to a woman, she's being treated differently than a man married to a woman would be. And so what I think you'll start to see is states reinterpreting or taking a close look at their own state laws and following the reasoning of the Supreme Court. So I think in Indiana, for example, I don't know for sure, but I think it's likely that we would reinterpret our state law similarly.
All right, Deborah, thank you very much. Appreciate your time.
Thank you. Nice to see you again.